Donald Trump, through his legal team, is admitting that they made a mistake when they asked that a Colorado lawsuit trying to disqualify him from the ballot be removed to federal court. In Colorado, a bunch of Colorado voters have brought a lawsuit trying to disqualify Donald Trump from getting on the ballot. You've heard this before in multiple other states through multiple other hot takes and Legal AF episodes and articles, et cetera, where we've all talked about and people have talked about the 14th Amendment Article 3, which essentially says that anyone who's engaged in an insurrection or rebellion is barred from future office. And several states so far have tried to bring challenges to this, including Arizona, Michigan, and in Florida, to disqualify Donald Trump from the ballot in the Republican primary. Just as a slight reminder of what this article is it basically says that anyone who is engaged in, not convicted, it doesn't say you have to be convicted, but anyone who's engaged in an insurrection or rebellion, that you are disqualified from holding future office. This was an amendment to the Constitution, the 14th Amendment, post-Civil War, and it had to do with the fact that there were many people in the South who tried to secede from the Union, engaged in an insurrection. None of them were convicted of crimes. And this was meant to bar those individuals from ever holding office. So the question, though, is how do you show that someone engaged in an insurrection or a rebellion? And many people, myself included, thinks, no, you don't have to be convicted, but there has to be some kind of finding, right? Somebody has to say, yes, this person engaged in, or there has to be a finding that they engaged in insurrection or rebellion of some sorts, right? Otherwise, anyone could just say anything about anybody. And so several lawsuits have been filed. One of them in particular has already failed, and this was a lawsuit in Florida because it was brought by individuals who sued Trump directly in federal court. And it appears that what's starting to shake out, that what's more appropriate is that these lawsuits be brought in state court, and that rather than suing Donald Trump, that instead you sue somebody like the Secretary of State of a particular state to make that finding, right? To say this person engaged in an insurrection and therefore has to be barred from the ballot. And in Florida, they did not do that. And so that effort failed thus far. But in Arizona, they've properly sued the Secretary of State. And in Colorado, they've also properly sued the Secretary of State in state court. There's 6 individuals who are petitioners who brought this action. And it's quite an extensive action that reminds you, when you read it, because it's quite long, of the Jan 6 report itself. It by and large mirrors the allegations in the Jan 6 report that clearly outline that Donald Trump engaged in an insurrection. A day after this Colorado motion was filed, the defendant, Donald Trump, tried to remove this action to federal court. But after conferring with him, apparently, his lawyers concede that he now does not oppose that this get remanded back down to state court, because federal court is very, very narrowly tailored. And essentially what they are conceding, what Trump's lawyers and Trump is conceding, is basically that they made a mistake, that they got it wrong. That not only did they get it wrong about what gets to go to federal court, they also didn't even procedurally get it right, which, frankly, he should have the best lawyers, right? He's grifting off taxpayers to get money to pay his legal fees. He has enough money himself, as well as through these legal fee super PACs, because that's essentially what they are, to pay the best lawyers, and they can't even get it procedurally right. Very strange. But let's just talk really quick. What's removal again? It's basically, there's 3 elements. We talk about it in many, many contexts here. It's happened in multiple times in the various Trump matters, which basically means when a state somebody's bringing a state court action, whether it's civil or criminal, if you meet 3 characteristics or three elements, I should say, you can get your case removed to federal court. Now, people might argue, why would you want your case removed to federal court? And that's a great question. And what's the difference between federal court and state court? And sometimes it's just a calculation, a strategic calculation that the individual is making, saying, you know what, I like the jury pool better in federal court because the particular state court jurisdiction where I am is much smaller and it's very liberal or very conservative, and I like the jury pool of a broader area. Or I feel that I have some immunities that I want to raise. You know, I'm immune from prosecution or from civil suit. And there are some federal immunities that if you are a federal officer, you could be immune from both civil and criminal actions, depending if you meet these three criteria, which I'll go over in a minute. And so there's several reasons why someone might want to remove to federal court. And what are the elements to get removal? You have to be a federal officer at the time or acting on their behalf. But basically, you have to be a federal officer. You have to be acting within your job description, you know, which they call acting under the color of office. But it basically means that you're doing no more than what is necessary to carry out your job. And number three, that you have a plausible federal defense. It doesn't have to be ironclad or for sure or 100%, but you have a plausible federal defense. So Donald Trump basically, tried to get this case to federal court, but very quickly realized they didn't have standing to sustain any subject matter jurisdiction in federal court. So, again, basically 28 USC section 1447C requires remand back down to state court if at any time before final judgment it appears that the district court lacks subject matter jurisdiction, i.e. constitutional lack of standing, which we have here. Federal courts are very limited in their jurisdiction, and there's a presumption against federal jurisdiction so removal is very narrowly construed, whereas state court basically has jurisdiction over everything. State court's a little bit of a free-for-all, but federal court's very narrow. You have to have meet certain requirements to have jurisdiction to begin with, let alone to be removed. And so essentially what's happening here, and what was argued by the petitioners or the plaintiffs, I should say, in Colorado was that that Trump ultimately agrees, is that there's no Article 3, what's called case and controversy, which is something that you'd have to show. They say that Donald Trump lacks standing because there's no case or controversy under Article 3 of the Constitution. The plaintiffs here are private citizens, and they're not saying, because for there to be a case or controversy, a private citizen has to allege actual harm. It can't be generalized. It can't be an abstract injury, or the generalized interest of someone, to get into federal court. It has to be specific. But here, the six plaintiffs are saying, this was just generalized grievance here. No one here is personally injured, and so therefore, as a result, we're eligible electors, under Colorado law. So we have the ability to sue in state court, but in federal court, there's nothing about it. There's nothing particularized of any sort of injury to any individual to get into federal court. So that's number one, that he doesn't meet the subject matter Article 3 jurisdiction in federal court. But he also didn't, in his filing, didn't meet a statutory requirement for removal. So essentially, the defendant in this case here is basically the Colorado Secretary of State, Jenna Griswold, and she did not join or consent to removal under 28 USC 1446 B2A, which mandates all defendants who have been properly joined and served must join in or consent to the removal of the action. But Trump didn't complete a docket sheet with his notice of removal. He didn't comply. He failed to comply with any statutory removal requirements. So in other words, what he's supposed to do is say, both I and the other defendants consent to removal. And he didn't say one way or another. He didn't even ask. So, that's just a kind of a technical failure, but he didn't meet that requirement either. So basically, this original cause of action that we talked about was filed, September 8th, 2023. And the petitioners, filed in the state of Colorado causes of action challenging Trump's candidate on the ballot and to seek an order declaring him disqualified under the 14th Amendment and enjoining the Secretary of State, Jenna Griswold, from taking any action that would allow him on the ballot. So, it's just interesting that he made two mistakes, but he also admitted it. So I guess he has lawyers who realize you can't make frivolous motions in court. You'll lose credibility with the judge. You can even get sanctioned. So he essentially is basically admitting that, no, this gets remanded back to state court. So he lost this opportunity to remove this to federal court, which he wasn't going to get anyway, because there really is no federal jurisdiction here regardless. So who knows if he's going to try to correct his mistakes and refile again. This could just be a delay tactic. I have no idea what he's going to do, but he lost yet another court battle. This one he didn't even lose. He conceded yet another court battle. And so stay tuned in state court to see if we can get Donald Trump prevented from being on the ballot because he engaged in an insurrection. I'm Karen Friedman Agnifilo with Legal AF. Join me and my co-hosts Ben Meiselas and Michael Popok every Wednesday and Saturday at 8 p.m. Eastern Time. And until the next Legal AF or the next hot take, I will see you soon. Bye-bye.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.